First item of business is Senate Bill 208. For purposes of carrying Senate Bill 208, the chair recognizes Representative Proctor.
Thank you, Madam Chair. I rise before the body to present House substitute for Senate Bill 208, an act relating to the Governmental Ethics Commission, establishing a 5-year statute of limitations for complaints, modifying the commission's subpoena powers, allowing respondents to have a hearing transferred before a presiding officer under the Kansas Administrative Procedures Act. Kansas Governmental Ethics Commission regulates the fundamental right of free speech. Please make no mistake about that. U.S. Supreme Court ruled in 2010 in Citizens United versus Federal Elections Commission that money spent on political speech is itself political speech. Kansas Campaign Finance Act regulates this money as well as compelling speech by forcing PACs, political parties, and candidates to put attribution statements on their literature and prohibiting speech and free association by limiting communications between candidates and PACs. As it's currently written, the Campaign Finance Act empowers the Kansas Governmental Ethics Commission to act as the cop, prosecutor, judge, jury, and executioner in campaign finance cases. This inherently jeopardizes the due process rights of respondents with cases before the commission. How can the commission act as an impartial judge and jury if they're also the body investigating, charging, and prosecuting respondents? A matter this serious deserves more scrutiny, not less. A matter this serious needs very deliberate safeguards to make sure Kansans' fundamental rights to speech are protected and Kansans are afforded due process during investigations and proceedings before the commission. House substitute for Senate Bill 208 begins to address this problem. There's been a great deal of media and social media rancor throughout the development of this bill. I'd like to publicly commend the proponents, the executive director of the Kansas Governmental Ethics Commission, and the chief of staff for the governor for working through all the misinformation and recriminations about this bill to arrive at this compromise we're hearing today. This bill does a number of important things to restore due process protections for those subject to the Campaign Finance Act. For investigative subpoenas, the bill lowers the threshold and the number of commissioners needed to approve a subpoena from 3/4 or 7 commissioners from the current law to 2/3, and removes the requirement in current law that all the commissioners be physically present. However, it requires court involvement prior to serving the subpoena to recipients. This inserts a judge in the process to ensure that the subpoenas the commission issues are legally sufficient, reasonable, and of proper scope. This bill creates a 5-year statute of limitations for actions before the commission, bringing civil actions online with criminal actions under the Campaign Finance Act. This bill also prohibits the commission from requiring respondents to waive civil or legal rights as a condition of consent order or final order. The bill requires the commission to adopt rules and regulations creating standards for when commissioners must recuse themselves from matters before the commission. Currently, at least 25% of the commission's funding comes from fines it imposes, creating an appearance that there's a profit motive for their findings. This bill raises PAC fees for larger PACs with the objective of making the commission fee-funded rather than fine-funded to address this appearance. This bill puts in statute what is currently just a rule of thumb, permissible uses of campaign finance funds. And among other things, it clarifies that payments of campaign or political staff is allowed if the payment does not exceed fair market value of services, and allows payment of civil fines assessed against the candidates or campaign agents and legal fees related to investigations or actions under the Campaign Finance Act. This bill requires a 2/3 vote of the commission to find probable cause and make a complaint public, and also allows respondents to request evidentiary hearings held before the Office of Administrative Hearings instead of the commission. The commission would still issue the final findings. Finally, this bill caps the fines at triple the amount of the fine for one count, but allows for a higher fine if a respondent derived financial gain from a violation under the Campaign Finance Act. It also prohibits the committee from requiring community service as an alternative to fines, reducing the potential for disparity in treatment between respondents. This does not prohibit the commission from ordering training on compliance with the Campaign Finance Act. Nearly all of the definitional changes that caused all the media furor over this bill have been removed from this bill. The only definition that remains is the refined definition of agent. This term is currently undefined in the Campaign Finance Act, creating ambiguity. As a compromise with the executive director of the commission, the definition does include unpaid volunteers who are authorized to act on behalf of the principal and does not require written authorization for a person to be considered an agent. Many of you received multiple emails from a prominent political consultant in opposition to this bill, and I'd like to take just a moment to address his concerns. First, this bill is not retroactive. It will have no impact on the matters currently being investigated by the commission. Second, to his objection that the definition of an agent, this language was accepted by the executive director of the KGEC because it includes unpaid volunteers if they are authorized to make decisions for a candidate. Concerning his issues with the fine caps, the executive director also agreed to this measure because it went from double the amount in the original bill to triple the amount and added the potential for higher fines if there was financial gain derived from the violation. The accusation that we're defunding the commission, sending fines to the SGF rather than the commission, this is an essential element of this bill. The commission must, in order to avoid the appearance of impropriety, have no financial interest in finding a respondent guilty. And finally, the compromise reached with the executive director was that PAC fees would increase to offset this reliance, so there should be no loss of funding. Thank you, Madam Chair. I'll stand for questions.
Is there further discussion? The chair recognizes Representative Vic Miller.
Thank you, Madam Chair. Would the carrier yield to a question? And before you do, I want to add my sincere congratulations to an excellent presentation today of both the bill and addressing some of those remaining issues. When this bill came across, it was a monster. And I think it now fits the classic definition of a gut and go. Would you agree?
I guess, yeah, technically that's what it is. We removed the contents of a bill that you probably wouldn't like and put the contents of 2391 in it with the compromise language.
Well, there's no probably about it for me. I didn't like 208, and I, again, appreciate what's been done. And my congratulations, not just to you, but all the people who were involved in making the current version acceptable. There was a lot of effort that went on, and all are to be commended. But here's one concern I have, and I'm going to ask you a question that you may need to yield to others, and I do not know the answer. It's not a gotcha question. If and when the Senate does not agree to our amendments and the matter goes to conference, are the original contents of 208 conferenceable?
Well, I would think that since the contents did pass one house of the legislature, they would be conferenceable.
Now I'm going to ask you a question that you don't have to answer, but it's important to me in knowing what I'm going to do on the bill as we currently are looking at. Will you give us a solemn commitment that you will fight to protect 208 in its current version and vigorously oppose including those provisions that came across.
Yeah, I will give you my solemn commitment. This bill was hard fought. Not everybody got what they wanted. Not everybody likes everything in it, but all the parties agreed to it, and I respect all the work they did enough to fight to keep the language the way it is.
And I accept that completely. Thank you for that commitment.
Thank you, Madam Chair. I just want to take one more opportunity to thank everybody who worked so hard on this negotiated settlement. I especially want to thank the members on both sides of the aisle of the Elections Committee. We voted on this bill 3 separate times to get to where we're at, and I very much appreciate all their hard work on this. And with that, Madam Chair, I move that when the body rises to report, it reports House Substitute for Senate Bill 208 favorably for passage.